Okay, Mr. Smith.
Morning.
Good morning. You said you met with Sean Davis. Sean Davis in the courtroom?
Yes.
Okay. We're on the record in the matter of Lansing Automakers versus Sean Davis, file number 06005995 Council appearance.
For plaintiff Lapku, Tim Smith, P48259. Good morning, Your Honor.
Mr. Davis, that is here in the courtroom in person, and the parties have met. Today was a date set for a show cause. Mr. Smith, did you get the information you needed, or do you need a new date?
We're going to need a new date. I did get most of the Q&A done. There are some documents responsive to your subpoena, in particular relating to an account with MasterCard, as well as some tax records. I'm going to send him a letter reminding him of exactly what he needs to pull together that is responsive, and give him some time to get that to me. But if we could have a continuation date, I'm probably going to have questions once I've received those documents.
Okay, sounds good. Is 30 to 45 days sufficient?
Mr. Davis, do you think 45 days is enough time to get me those documents?
I can try, yes.
Oh, if it's not, you can just say you need more time. I don't know what the documents are. Just
Well, you just wanted the records from the MasterCard, correct?
The last 6 months of account statements related to that debit card, correct?
Yeah, and I don't know how, I have to reach out to them to see how I can get those, so.
okay, we'll do 45 days. We can do April 18th at 2 p.m. April 18th at 2 p.m.
Okay.
Do you have any questions today, sir?
No.
Okay, we'll get you a copy of your notice to appear. Any additional matters on this record, Mr. Smith?
There are none. Thank you, Your Honor.
Thank you. You're all set, sir. We'll get you a copy of your notice. Okay, did Amanda Herbert appear? Okay, Amanda Herbert failed to appear as a bench warrant can issue.
Current balance on for bond consideration, Your Honor, current balance is at slightly over $3,500. We go 10%.
That's fine. 10% is good.
Okay, we'll prepare and submit at 10.
Thank you. And then Kayla Barr, is Kayla Barr here?
She probably isn't here, Your Honor. She and I spoke a couple days ago, and I think we may have the whole matter settled. She did tender a check for payment in full. It arrived late yesterday. I'm assuming it's going to clear. What I'll do, if it doesn't clear, and I anticipate that it will, I can simply file a motion to show cause. How's that? And if it clears, I'll file satisfaction judgment. We'll get the case closed.
Sounds good. I'll note that in the file. Does that take care of everything you had today?
It does. Thanks for the help.
Thank you. Have a good one.
You as well. Hey, Ron, good to see you.
Have a good one. Okay, and Mr. Stock is here for hearing. Motion to stop eviction. Pete Fox is here. Lasharion Rogers. Lasharion Rogers here. Okay, we're on the record in the matter of Farm Bureau Insurance versus Lasharion Rogers in file number 22-02133 GC. Council, may I have your appearance, please?
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff P59146.
The date and the time that was set for a motion. It was the defendant's motion to set aside a default judgment. This matter was scheduled for 8:30 in the morning. It's currently 9:18, and Mr. Rogers has failed to appear, so the motion is denied.
Very good. We've not heard from him, so thank you, Judge.
Thank you. You're all set.
Thanks.
Did Liam Maya appear?
Both parties are here today.
Where are they? For a pretrial? Did they complete they couldn't work out a joint pretrial statement? Okay. We're on the record in the matter of Elia Maya versus Dependable Auto Sale, file number 22-02329 GC, council appearance.
Frank McAlpine for Mr. Camille.
What's your name, sir? Elia Mia. Today was the date set for a pretrial. And the purpose of the pretrial is to see if you can resolve the matter, but if not, you need to come to a joint pretrial statement so that I can get a scheduling order. What's the problem?
Well, Your Honor, we will accept from the court whatever dates the court gives us, but it's hard dealing with a pro per plaintiff because they don't know the procedure. And I tried this before. We would be happy just to give us regular dates. I sent him the investigative report, the fire investigator, everything about this already. I filed a pretrial statement for the court to read about what's going on, but it's just very difficult.
You
to
filed a
do.
pretrial statement when?
Yeah, I did a couple of days ago, but it explains, now this is not with dates on.
I was gonna say it's not in the file yet.
Okay, I filed it probably Monday, just to give the court, and I sent it to plaintiff, but we would just request the court give us dates that are convenient to the court and convenient to the plaintiff.
Yeah,
We don't
well,
need
we're
this
not
stuff.
doing that. We're gonna complete this form. That's how we kick out our scheduling order. I'm not gonna just pick random dates. You're gonna follow the procedure, otherwise I'll sit down and spoon feed this procedure, but you all gonna figure that out. And we have at least one attorney here, so that's not a problem. We do this all the time.
Okay. With me.
Discuss if there's issues, you know what an issue is. You can put it on there. We'll go over it on the record. If you have any questions, he's not your attorney. You can ask the court. I can't advise you on how to proceed in your matter, but I can explain anything you don't understand about that. But you need to work to get that completed, and then we'll get it filed. And that's how you get your dates for a hearing. If you guys can't do that, then you can't move forward in this case. Do you understand that?
Yes, ma'am. So for me, I don't know. Because it's like they don't wanna like negotiate with me, you know.
They don't have to negotiate with you.
Because
Margaret, I say one thing.
Yes.
Is I said it at the last hearing, he's suing the wrong people. I sent him a copy of the report of the insurance company that covered the building.
when it was nothing. So
You say you haven't seen it? Did you send it this week?
No, I said it over 2 weeks ago. I just came in and dropped it off in court yesterday because I knew it was coming from.
Okay, because I haven't seen whatever you filed yet myself either.
Mhm.
But if you have a copy for him, maybe he can get it now since he's saying he hasn't seen it.
Don't have it with me.
Okay, maybe we can correct how it was sent. Maybe it wasn't sent in a form in which you can receive it. I don't know if you have his address, if your address is
It was
changed.
sent by me.
Okay, did you change your address since the last court date? Okay, I don't know why you didn't receive it if they sent it there. I couldn't speak to it. Maybe give them your email address and they can email it to you. Okay, you can go in a private meeting room to get that taken care of. Tony Thomas and Abigail Smith. Are they here? People filing these motions and they don't want to come to court. Okay, we're on the record in the matter of North MLK LLC versus Tony Thomas and Abigail Smith, file number 22-04027. Council appearance.
Yes, good morning, Your Honor. Ronald Bach here for North MLK LLC.
Today was the date that was set for a hearing for a motion to stop eviction, and it was scheduled for today at 8:30. It's currently 9:23. Neither of the defendants have appeared, so their motion to stop eviction is denied.
Thank you, Your Honor. Just so the court knows, they're not getting evicted. This has been paid in full. This writ is not getting enforced. We've informed the process server already.
Okay, I will also note that in the file, but for the purposes of the motion, they still didn't appear. They should have withdrawn it, but I'll consider it resolved.
Thank you, Judge. Have a good day.
Thank you. Have a good one. Same to you. What's your name, sir?
Kurt Tightsy.
What's your name? We're on the record in the matter of Kurt Tightsy versus George Runciman, file numbers 23-00109 GC. And both parties present in the court. Today's the date and the time set for a motion to set aside a default judgment. That. Let's go to this file. It's part of the problem. I don't have the ROA is not properly in this file. This is 22-00901. I don't know if I'm missing something. I also don't see a motion to set aside. Oh, definitely.
Yeah, I asked, what does that mean, to set aside a judgment?
A default judgment.
Yes, is that me or Mr. Runciman?
So
What does it mean to set aside?
default is when the defendant fails to appear. And so a default, okay, I do see the motion to set aside default judgment. This is Mr. Runciman's motion. And there was a default judgment that appears that was entered. Or we submitted to the court by you. Sent it on February 2nd, correct?
I'm sorry, I didn't hear.
Did you file a default judgment against Mr. Runciman?
I filed a small claims court. It was supposed to take place in December. And Mr. Runciman pushed it because he said he needed more time to get 2,000 photographs to me that would disprove that he left me with a
I
pile of
recognize that you did that, but my question was, did you default him in this matter? That-
Oh, excuse me?
No, is that your signature on this document?
Is that from a small claims court?
This is from this court. This is not small claims anymore.
Correct.
Is this your signature here?
Yes.
Okay, so this is a request for a default. Did you renew?
No, I even told them that I was not forgiving him of what.
I didn't ask, do you know what a default is?
But that's why I asked you.
Yeah, default means if they don't appear to court or then you can automatically win the case.
Correct.
Okay, so that's what this is. A default, a request for default.
Okay, and then Judge Millimore, Magistrate Middle,
Well, we're
No.
not talking about what happened in small claims.
but he didn't file in
Well,
a timely manner, so
I
on the
get-
second,
I
I'm
get
supposed
that.
to have won.
I get that he didn't file anything timely, but this is no longer before Magistrate Millmore.
Correct.
So that's why I'm not dealing with that. I'm dealing with what's happening up here. And he appeared before the court, and it looks like he was supposed to file something within 14 days. And he was supposed to serve the court, you and the court with that.
He did not.
And well, I'm gonna get into that in just whether or not he did in a minute. But my first question was, did you file a default? You signed this. This is called a default, sir.
So this back.
Okay, you're not focusing on my questions. You're focusing on what you want to tell me. Focus on my question first, because I'm trying to get clarity on what's going on here. You signed this document, sir?
I believe I did, sure. Yes.
Okay, this is a default. So that means that he failed to appear or provide some documents he was court ordered to do in this case. So you requested to default him, meaning you wanted to win the case.
Correct.
Okay,
Yes.
very good. So your original question, which is why I'm going through this, is what does the motion to set aside the default? He's requesting to set this aside.
He is requesting.
That's what today's date is for.
What am I requesting?
I didn't ask you what you were requesting. You filed this to
Correct.
default him.
On the
He was-
February 2nd.
Correct. He was notified that you filed this to default him. He came in after that.
Right.
Within 5 days and filed this to ask to set this that you filed aside,
Okay.
meaning you
Right.
reinstate this case.
Because-
Because when you default the case, that means the plaintiff automatically wins. We stop, we don't move forward. The judgment is against him because he didn't appear. He's requesting to set this aside, and he's today going to provide us with the reason why he believes it should be set aside. That's all I want to hear about. I don't want to hear about anything else but why he thinks there's a reason to set it aside. So all this, the stuff that you have, that doesn't come in today because I have to determine whether or not it's going to get set aside. If I determine it's not going to be set aside, then all you have right there doesn't matter because you already won the case based on this default. If I determine that he has good cause and a meritorious defense, and so I'm going to grant to set aside, then we'll deal with when you get to tell me that information. It won't be today, but there'll be an appropriate time to do that if I later determine. But I don't know what I'm going to determine yet because I'm just trying to explain to you what today's date's for.
So I want to move forward, correct? Is that
You want to
what-
move forward with the case?
Yeah, yes, I want you to hear it and then decide whether I win or lose or however. we
Okay,
want.
I don't think you get what's going on then. You definitely don't get it. Because you're technically, as of right
I've never
now,
been here.
I know, but as of right now, that's why I'm trying to break it down. As of right now, you already won. So you don't have to tell me anything, but you won by default.
Correct.
That's what a default judgment is. You know what, when you win something by default? You get it?
Right.
So you
So
don't
I
have to.
don't even need to be here?
No, you do need to be here
Okay.
because you was ordered to be here for a hearing to set aside your win by default.
So what are my choice? I don't understand what my choices are. Is
Your
it-
choices are for me, I'm only explaining this because you asked the question. Your choices are to sit there quietly and answer the questions I asked, okay?
Got it.
But do you now understand
I do.
what today's purpose is for?
I guess it's for him to prove that I'm wrong. Is that correct?
No.
No.
I went over it, but you weren't listening. So calm down, listen, and listen again. I'm gonna go from the beginning. There was something he was supposed to file within 14 days, correct? I'm assuming it has to do with an answer. Is that what it was? He filed the complaint? Who filed the complaint? You filed the complaint against him, correct? He was supposed to answer you and he didn't do it. The magistrate gave him an extension to do that. You had to do it within 14 days.
Didn't follow through.
And you're saying he didn't do it, which was what brought you here, and you filed this with the clerk's office. This means he didn't answer, which is the same as a period to court almost. And so you want to win your case by default. So that's what this paperwork did for you. It made you win by default once we signed and entered it. But under the court rules, he has a certain period of time in which he can come in and request to have that default set aside. But he has to then tell the court why he didn't do what the court told him to do, and if he believes he had a good cause and a defense to a meritorious defense. And that's what today's date is for. That's all it's for. So as of right now, you're still in the default win category, okay? So you don't get to tell me anything about the case because you don't need to, because you won so far. Now, he's requesting to take that default win out the system and reinstate the case. If the case gets reinstated, and I don't know if it's gonna get reinstated or not, but if it does, then we'll talk about when you'll have an opportunity to prove your case, okay? But as of right now, we're not there yet. As of right now, you consider yourself winning, okay?
Thank
You filed a motion to set aside the default, and you said that you sent the letter to Mr. Titsy within the 14 days, but did not send it to the court. I am seeing, or does it say seeking counsel?
Attorney, yeah, counsel.
Okay. Did you hire an attorney?
I talked to Your Honor, I was suggested by the magistrate to get an attorney because I'm 80 years old and I get a little confused on some things. But what happened was,
Well, let's just ask one question. Did you hire an attorney?
I went and talked to him, it was $200 an hour. He said it'd take months to go through all the pictures. I gave him all the attorney there. So I think I should qualify for, I don't understand the Zoom thing, I wanted to do that, but the magistrate, said I did what she said. The reason I didn't send one to the court.
I'm sorry,
Okay.
let me stop you because I asked a very specific question. I don't know what's going on here. I reckon you look very good for 80, number one. But I need you to listen to my questions and answer. There's a reason why I need an answer to the question I just asked you and not this other information. Did you hire an attorney?
No, I'm still looking for one, and I need one appointed, probably.
Okay, you don't get an
money
appointed,
wise, but
you don't get an appointed counsel in a civil matter. You don't have any rights to appointed counsels here, and we don't appoint counsels in civil matters.
yeah, right.
Okay.
Right, we're out of that. Yeah.
You would have to hire an attorney or you represent yourself. You only get an appointed counsel if it's a criminal matter. This is not a criminal matter. Okay.
The reason, can I tell you why? Because I got signed to you, it didn't give a date, but I was signed to you. That's where I made a mistake myself. I sent a letter registered to Titsy. And I mailed that to him in the amount of time I was supposed to. 14 days or 21 days, I forget what it was within 14 days, maybe 21 days. I had to do it. You get the letter that I sent to him.
What letter did you send?
I sent him one, what she told me, the way I understood it. Now, maybe I got mixed up. That's why I need an attorney. It might have been mix up was I didn't send one to to the judge because it's already assigned to you. And I had a different register, a different claim number. The claim number was different, so it was already sent to you, and it didn't make any sense to send it to you because I was already lined up with you in the case, a different case number. You moved up from small claims to the higher court here, so that's where I admit that. Maybe I had confused on that.
Did Magistrate Milner tell you that you need to file an answer to the complaint?
No, she mentioned a bunch and maybe I got mixed up there, but I was understanding to send to him and I did.
What did you send to him? Show me what you sent him.
I don't. He's got it there. I didn't bring it. I didn't think it.
It's not really proof.
I've got the receipt from the post office that I sent it and then told
Let
him.
me see the receipt.
I didn't bring that, thing, but I can bring it to you and show you. He's got it. Did you?
How do you know? How do you know if he got it?
Because I had it registered.
Okay, well, you need to show me the proof.
I went to Collins Road.
I know, but you got to show me the proof, sir.
Yeah, I didn't know I had to bring that.
What do you think he was coming to court for? You requested this court date.
Yes.
So you was coming to show us the proof that you did what you said you did here.
Yeah. I did that.
I know, now I want to see the proof that you did it.
I can bring that in. It was a. It's like this, that wasn't in this code. I might have it here. If this is the code I was wearing. You can ask him if he got it. He's under oath and he should tell. Your Honor, can you ask him if he received it?
Did you receive the answer from him?
Late.
No, I didn't ask you when you received
I
it.
received the same letter that he and I signed.
So you
in
did
front of
receive it. You
magistrate
did receive an
Miller.
answer then.
Not in a timely manner. And he sent it to
Oh, okay.
me,
He received it. He received your
but he
answer.
didn't.
Yeah.
I'll set aside the default.
Thank you, Your Honor. The attorney that I talked to, he said it'd take months to go through with him, so I'm gonna find another attorney. Hopefully it's cheaper than $250 an hour. It's gonna take quite a while to set up a date.
Take quite a
Again, if
while
I
for
get
what?
told to go through all the, I got 20 pictures, I gotta go through individuals, he sent me some pictures. And I'm gonna correspond, this is down the road, you know, separate indeed.
I'm still awaiting 2,000 photos that he was supposed to send me in
This
December.
might be what's here in this file. I don't know what this
Those
is.
are my photos.
Those are yours? This is your, all part of your complaint? Is that what this is?
Yes.
Okay, couple things. We don't have your answer in this file. You have to file it with the court too. Where's our copy?
Well, that's what I was looking for, from, you mean the one that they sent to him, right?
Correct. We need one for the court.
Yeah. I'll bring that to you.
Do you have it, sir? It's just sit right there. Yes, please.
It was the same thing that we both signed in the registry no more on the day that she dismissed it or whatever to this court. I signed one and he signed one, and he sent me his form
Is this what you sent him?
I sent him,
in this.
yeah, that's the registry.
Is this what you sent him?
Yeah, I think that's what I sent him, yeah.
Okay, this is not an answer.
Not answer to.
This says, the case is moved to General Civil Division of the court. The defendant has 14 days from the date of this order to file a written answer and serve it on the other property or take other lawful action within the court.
Yeah. I'm getting confused on it, but
What part are you confused
that's why I
about?
want to, that's why I want to get attorney, get it straightened out.
Okay, well, this was back in the 18th of January. It's March.
Yeah.
Where's your attorney? Did you bring one?
I didn't bring, no, I'm
Yeah.
gonna get one. I'm still checking for one. If I can't get a
Even
court
if you,
appointed, I didn't know that. Now I know
you
it.
can't get a court appointed because this is a civil matter,
I understand.
but you still you needed to, whether you can afford an attorney or not,
Yeah.
you're being sued. And this is plain language here, it's bolded. You need to file an answer. Do you know what an answer is?
Well, yeah.
What's an answer?
To what you have there.
No, you're not filing an answer to this.
Well, that,
This is just a notice saying that the small claims lawsuit.
Mhm.
Are you listening to me,
yeah,
sir?
yes, I'm trying to.
This is just a notice saying that the small claims lawsuit that Mr. Titsy filed against you was moved from small claims to the general
Right.
civil division of court. That's how I got the case, okay? That's all this is. But what you're filing an answer to is to his complaint. Did you get his complaint? I don't know if you got it there. Because we got a lot of stuff here in this file. Did you
Yeah.
give him a copy of all this
I
stuff here?
certified mail to him.
Did you ever get all of this
Yeah,
stuff?
he sent me that. That's why
Okay, yeah.
I want to go to court to answer everything.
No,
And I
no,
got-
you
I
don't go
guess
to
when
court
you
to
take-
answer it. You don't come here to answer it.
I know that. That's what I want to do is, have my time in court.
Right, you
Yeah.
need to respond. I'm trying to find the actual complaint in here. This is a lot of stuff here. Pictures, there's a lot of pictures. Where's the actual complaint?
The original one.
Correct. I don't know why they make files like this.
What's the date on that? I respond to him, but he sent me, what was that date? You have it there?
Give me just a moment. So this is the affidavit and claim of small claims. It says here on the bottom. Get this, when he filed the small claims action,
I believe so.
you don't believe you got a copy of the small claims? How did you know you were being sued, sir?
I can't see it, is it? No.
Okay, this
He
says,
sent me a whole list of things that it might be in that list.
okay, this says back, the claims arose on September 5th, 2022, and that you still owe him $150 for rent until September 5th, and that he's claiming $5,460 plus $150 for a total of $5,610. He said that you paid a friend to move belongings out of 6023 Orchard Court, Lansing. The friend began late in the month of August 2022 and turned in your key 5 days beyond the court order move out, which was August 31st. You remember getting this paperwork, sir?
Yeah, I think.
Okay, so that's what your response, that's what it, so an answer is you gotta respond to it.
Yeah, okay. I'll find it Monday now.
We're gonna give you a copy of this today while you're here. You're gonna set aside the default. Because I can clearly see both of you seem to be a lot confused about this process. And it can become even more confusing because you filed it as small claims. It was moved to civil, a general civil in the court. And I don't even think you understood what you were coming here for today yourself.
Yes,
So,
I didn't know what you were asking me about.
correct. So nonetheless, I'm going to set aside the default judgment. I'm going to tell you today, sir, I'm going to give you a copy of this complaint. Do you know where Mr. Bigelow is? Look at her. Mr. Bigelow in front of you, please. Okay, I'm going to give you a copy of what was filed against you. You have 2 weeks. You need to file an answer. I don't care if you're gonna hire an attorney or not. You need to file an answer. It's not even likely based on what you're being sued on. I don't know if you can afford the attorney or not, but you need to file an answer. You need to serve your answer on him and then give us a copy within 14 days. Do you have a question about what an answer is?
No. Well,
Okay.
when I get the form, I'll read it over again.
Yep, yeah, well, yeah, you can get an
Do I
answer.
have to answer everything he wrote down there? on
You need to
that?
respond to this. You can
Everyone.
say, you dispute it. That's an answer, but you need to respond. And you can get a copy of the answer when you leave here. You go down to civil and get a copy of the answer form that you can respond to this with, okay?
Okay, where do I go to get that?
You're gonna go down to the civil department. We're gonna send you down there in
Okay.
just a moment. Can you give him a copy of this? Yes.
This was fully explained to him by Magistrate Millmore.
Well, I don't know that. I wasn't there.
He said he agreed, he knew what she was saying, he understood her, he's playing the game.
I
He has
recognize,
a very high job with a lot of responsibility. He's not brain injured. He drives for handicapped children.
I
For
don't know that he said,
transportation.
he didn't say he was brain injured, at
He
least not to
says
him.
he's not.
He said he's 80
understanding things.
80 years old. This is what he said.
Perhaps he should
Well,
not be
yeah.
driving handicapped children.
Listen, sir, I had to explain default to you 3 times, so
I've never
well, we're
been-
not gonna, yeah, well, exactly. So if you want some grace and understanding, then I understand that he probably needs some too. He didn't bring the lawsuit against himself.
This is the fourth time.
You brought the lawsuit against him. So it's reasonable that if you don't even understand the process and you're bringing the lawsuit, he probably doesn't either. And then it's been moved from from small claims to general civil. And so this is the first time I've seen you.
It's because
So-
he wanted a jury and his attorney to be.
He
He
has
said
a
he
right
had his
to,
attorney.
he has a right to
Judge
do
Miller.
that. He
He
has a
said he
right,
had one.
he has a right to do that. And so,
Okay.
and then I have the right to, and the responsibility to give leniency when I'm dealing with individuals who are not represented by counsel. And so that's why I'm taking extra time to explain things to you. That's why I'm allowing you to talk over me in my courtroom when I'm on the record, even though that's grossly
I'm
inappropriate.
sorry. Will I also get the 2,000 photographs that were promised to me in December?
Who
He's
promised
got
you?
2,000 photographs that prove my pictures are false.
That's up to him.
I,
I can't speak to whether or not he's gonna use any evidence to his defense. He doesn't have to bring any evidence. But what we're gonna do is, because I've now set or granted his motion to set this aside, we're gonna get his answer. We're gonna get a scheduling order. It's gonna look similar to this, and then it's going to give you a discovery deadline. You can request any documents relative to this that you want from him. If that includes some photos that he has, then you can demand that from him.
I do demand that, and I did.
Well, you
demand
can't
it in
do it,
small
you can't,
claims.
you don't demand it
In
here in the
small
court.
claims, I told her. I
Yeah, but
wanted
we're
it.
no longer in small claims.
So does it carry on?
No, this is general civil. I'm not picking up on whatever she started with. We started all over when it was moved here.
So
Okay.
none of those photos that I've sent you.
There, whatever you
thrown
sent,
out?
they weren't sent to me, they were sent to the magistrate, but they're in this file.
Those get thrown out, so.
No, they're gonna sit here, but I'm not gonna do anything with them. They just sit here. And if you're gonna have a trial, whether it be a jury or bench trial, and I don't think that we got a jury demand, but if we're gonna have a trial and you're gonna use any of these as an exhibit, then you have to then have a copy of them for your exhibit. I don't have to provide your
I've got
exhibits.
my copy.
Yeah, but you
So
would have
those will
to,
stay with the case.
those are gonna stay here,
Thank
but
you.
I'm not gonna review these. If you're following a motion and you're relying on any of this evidence, you need to submit a copy of whatever evidence you're supporting your motion with. If you're gonna have a trial and you want to submit evidence to be reviewed at the trial as an exhibit, even if it's in this, you need to give another copy of it. This is just gonna sit here because this was filed with your complaint. So this is considered a part of your complaint file at this point. I'm not searching through this to review anything because it would be inappropriate for me to do that when it's not the time for us to do that.
If he brings pictures to the next, then you can look at those or no?
No, we don't just come bringing pictures to hearings. We only, if you file a motion and you attach an exhibit, that's how you get it before the court. If you have a trial or another hearing and you enter an exhibit at the hearing or at the trial, that's how I get to review it. You're not just gonna come in here and start dropping off photos for me to review.
So I, in the next 14 days,
He's gonna file an
I need
answer.
to get you 200 more photos. Of that, of what I just.
This is exactly why, this is why you can't talk about his understanding, because you don't understand either.
You said I can't.
I don't, you're not gonna get me anything in 14 days. He's gonna get you an answer. And once I get an answer, we're gonna set this for a pretrial. You're both coming for a pretrial. You're gonna come in person because I don't think I can conduct anything with you all outside of being in person. And then we're gonna do one of these. This is called a joint pretrial statement. And we'll go through line by line and we'll set this on a date and time. This is for Mrs. Nash's understanding, in which we have plenty of time to explain this to you all, because I think it might require that. And so that you can set out a date so that you can request discovery, a date where you're gonna need to give your exhibits. That's what you're talking about, pictures. Those are exhibits. Don't come here in 14 days and just drop off some stuff, because it's just gonna sit in the file. I can't do anything with it.
I wait till there's another trial. And then
You wait until there's actually a trial. We've not had a trial yet.
Can you make a ruling on that?
A ruling of what?
Ruling either for or against my complaint. For
I can't make-
$5,700.
Did you, when you filed this, did you read the court rules? That's the order I'm making. You read the court rules. Because you're bringing a lawsuit, you need to know how to do it. I don't just make a ruling on your complaint because you filed one. this is not small claims. You're now in the general civil division. You need to know the general civil court rules, okay? And there's a process that we have to follow. And so we have to follow the process. I don't get to just make it because you follow that. That's what I'm telling you. I don't review this. You got to go all the way to trial, or you got to get it before me on a motion, maybe a motion for summary disposition, or it could be a motion for a motion before we get to that point, because maybe he doesn't file the answer again in 14 days. Either way, because if he doesn't file in 14 days, this is your last chance. You can come back and do this again.
I can do that today. You tell me where I should go to.
You're gonna, when you leave here, you're gonna go down to,
There's a line there with dispute. And I just put dispute and then
you're going, and you're gonna put why you dispute it, okay?
you got to put why.
Yeah, yeah.
Every one of his,
Yeah, you're gonna explain why you dispute his complaint.
I'll need another sheet of paper.
I'm sorry?
That's what I'll need.
Can you give this is Mr. Tipsy. Can you give that back to him? Who filed? Oh, these are exhibits filed by plaintiff. It says here for these from Robert Snow, Gina Marino, you filed that?
Yes, those were people who helped me to bag up and box up nearly 5 tons worth of debris and
Okay,
garbage left over.
so because I'm aware that you haven't read the court rules, I would never be able to do anything with this, okay? Do you want to know why? These are just some letters that you had signed. These are not anybody that's under oath. If we're gonna have if you want to use their statements, you need to bring them here. I'll put them under oath, okay? And don't just bring them here on a random day. You'll bring them here at the trial date, okay? All right.
They were antiques. He called them.
I don't know. We're not talking about facts today. We're not talking about that.
Okay.
We're talking about what you're gonna do in 14 days, which is what?
Yeah, I'm gonna dispute it. Now answer everyone on the sheet you're gonna give me.
Yo, he's not gonna give it to you.
Well, whoever gives it to me.
Where did I tell you to go to get it?
So you're gonna tell me where it is.
5th floor, civil department.
Therefore, I know it.
You see that gentleman right there, right behind you? Look behind you, bald head, that guy?
Yeah.
He's gonna show you exactly where you're gonna go, okay?
I was just there about an hour ago.
Oh, so you do know where the civil
Yeah.
division, oh, wonderful,
Yeah.
good. So you'll get the information from them and we'll get this set for a pre-trial once we get your answer, okay? Your answer needs to be served on whom, sir?
That gentleman there,
And who else gets a copy of it?
you get one in the court.
Thank you.
Your Honor,
Yes, sir.
if after I'm served his paperwork, at that point in time is when I need to get you more information.
No. Once we get the answer, we're gonna set it for a pre-trial.
I'll get
Then you'll
over it.
both come in and then we're gonna complete one of these worksheets. And this will give you some dates and deadlines about what you all need to do next. But what you're gonna do between now and the 14 days is what?
Wait for his,
And what else did I order you to do? Read the court rules.
district court.
Not just district court, you're reading court rules on civil procedure. You're bringing a civil lawsuit. He's not bringing it, you are, okay?
Yep.
So you need to know what you're doing. He needs a copy of I put a sticky note on it. It's a copy of the complaint. Yes,
Have obtained the rules and civil procedures, floor 5, 5th floor.
no, you can't find those on the 5th floor. We have to pay, the court pays for us to have copies of them, but you probably can Google them. Okay. You have any other questions? You have any other questions?
Google would be good for a.
No, it's just general Michigan court rules. You're Googling the Michigan court rules for civil.
Court rules
Civil.
for-
Just say civil, Michigan civil court rules, then it'll bring up the court rules. And then you should probably figure out what you're doing since you want to bring this lawsuit. And then you'll understand better when we come to do this pre-trial. And if you're not hiring an attorney, you're gonna need to do the same. You understand?
I have to, do I have to have an attorney? I do.
Yeah, it's up to you if you want to have an attorney. You can defend yourself, but you might end up in trouble. You might end up owing money or you might not. I don't know. But
You know,
that's a
he'll
risk
need
you
more
have to
money than
evaluate
he's
for
got.
yourself.
Well, he's going to need more money than he's asking.
I don't know that. That's not before the court, okay?
Well.
If you're filing a countersuit on this, you need to get the paperwork downstairs at the civil department as well, okay? Any other questions? Any questions for you, sir, Mr. Runciman?
No question right now.
Thank you. You're all set.
Thank you.
Okay. What should I do with this file? You all can come up. Back on the record in the matter of Ilya Maya versus Dependable Auto Sale. And I have a joint pretrial statement here. Signed by both parties. It says the issues. Question is whether defendants are responsible for damage to plaintiff's automobile. What are the damages? You said the damages are $15,000, sir? Okay. And pleadings are in order or acceptable at this point. I'm assuming there's gonna be some motions filed, and I'm positive you're gonna file a motion to dismiss or something, because you believe you're the wrong party.
Well, you can always sue even if we'll see, Your Honor.
Okay, well, discovery. Is this second? I don't foresee there needs to be much discovery on this. I'm gonna give you 60 days for discovery. Will be May 2nd, 2023. Discovery deadline. Do you know what discovery is, sir? Discovery is when you want to request information or documents from the other party to help support your case. Okay, so if you needed records or anything like that that you think that they would have possession of, you would do that through discovery. If you're going to bring a lawsuit, you know what you need to do? You need to read the court rules. Have you read the court rules?
Some of them.
Which ones did you read?
That's all, but like, can you just try like make me understand me?
I'm sorry?
Can you try to make me understand? please?
I don't have to try to make, you're the one who's bringing the lawsuit, and then you have an attorney. You see this guy right here? He knows the court rules. If you want to prevail or have some success in your lawsuit, you're gonna probably want to know the court rules, because he's gonna use them. And he's gonna call you out when you don't use them properly, okay? And so I can give only so much leniency for you, considering the fact that you're self-represented, but I can't just let you come in here and run a circus in the courtroom because you don't know the court rules and you don't want to avail yourself of them. They're on Google. You can get the court rules. You need to know what you're doing if you're gonna sue, okay? And so he's already told you that he believes you're suing the wrong person, okay? So you should anticipate he's gonna use these court rules to try to show you that, okay? So you find out if you need discovery or not from this party, and that you have to do that. Discovery needs to be completed within 60 days. I'm gonna have motions for summary. They'll be due 30 days after discovery. June 2nd is a Friday. Exhibits are just gonna be a picture of the fire. Is that?
Picture the vehicle as it was burning.
Okay, they just need to be exchanged 1 week before trial. Unless you're doing formal discovery. If you don't do any discovery, it's different.
He has some of the pictures already. so.
Okay. Expert witnesses, who's calling an expert witness? You are?
We probably-
You are? You plan to, as
Yeah,
a
there was
fire
a
investigator?
investigator who
Okay.
prepared a report for the insurance company,
Okay,
but
who's plaintiff's father and plaintiff?
My dad was, so he asked me about if I can find a witness who were there, like the time about my dad.
Got you.
My
But
dad-
this is just for, this section here is only for expert witnesses. And your father, I don't believe he would be an expert in this case, correct?
Was there the time about my dad there.
Okay, that just makes him a witness, not an expert. He has to have a specialized training or something or skill relative to this to be an expert, okay?
All right, man.
So, and so you can list the list of who you're gonna call as witnesses. You can do that during discovery, okay? But that wouldn't be an expert witness. But if you're gonna hire a fire investigator or expert, obviously, you know, the court rules as it relates to that. We'll address it at that time, but I'm gonna cross out father and plaintiff because,
that was my area.
okay, no worries, because this is only for expert witnesses. There's no joinder of claims, a bench trial, possibly 2 hours, possibility of settlement is poor. You don't think that you benefit from case evaluation or mediation. I would agree. You both signed it. I'm gonna sign and date today. We'll get you a copy of it, and then the civil department will get you a scheduling order in the mail based on this. What's your street name?
During the street.
Okay, so you're still at that same address, is it 1131? Okay. Okay, do you have any questions? Any additional matters for the record today, council?
No,
Thank you. You're all
Thank you.
set. Okay. Mr. Sarts, are you here with Mr. Copeland?
Right, Your Honor, yes, we anticipate a waiver.
Who's the prosecutor?
Would you like me to go, Mr. Ray?
Oh, yes, please. On the record in the matter of the people of the state of Michigan versus Calvin Copeland, file number 23-000489, FY council appearance.
Brian Ring on behalf of Field Practicing Inter Michigan Court Rule 8.120.
Good morning, Your Honor. Jacob Sargent, fourth assistant public defender here on behalf of Mr. Copeland. Mr. Copeland is standing at the council table to my right.
Thank you, Mr. Copeland. Today's the date and the time that was set for a preliminary examination. And my understanding is that there is an unconditional waiver of this to the circuit court. Is that correct, Mr. Ring?
That is correct, Your Honor.
Was there an offer?
There is, Your Honor, may I have 2 seconds here? The offer was at this time, Your Honor, to plead to count 2 of the charge, the carrying concealed charge, and the people would dismiss the remaining counts upon successful plea and forfeiture of the weapon.
Okay. Okay, and Mr. Copeland, you want to waive your examination today?
Yes, ma'am.
You understand that you have the right to have a preliminary examination here in the district court, and that the purpose of the examination is to have the prosecution meet their burden, which is to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? You want to unconditionally waive that today?
Could you repeat that?
You want to unconditionally waive your right to have that examination today?
Do I want to have my examination?
Do you want to waive the right?
Yes.
Okay, so you don't want to have the exam. You understand that the waiver is unconditional, correct?
Yes.
There's no promises or threats being made to you to get you to waive your examination? You sure?
Just other than dismissing count 1 and 3.
The offer is enticing to you? Is that what you're saying? Is but there's no promises other than that offer, correct?
No.
Okay, and no one's forcing you to waive your examination?
No.
Okay. Your bind over date's gonna be March 15th. That's the date that the circuit court gets the file from this court. You do not need to appear in circuit court on March 15th, okay? You will not have a new arraignment in the circuit court unless your attorney makes a motion for some specific reason as to why you would need to be rearranged at the circuit court level. And your next court date at circuit court is going to be a pre-trial. Both you and your attorney will be made aware of that date, okay? What's your address, sir?
303 Sagewood, apartment 7.
Is that the address? Yeah. Okay, bond was set at 15,000. Personal recognizance that will continue. Any additional matters for the record?
Nothing on behalf of people like you, Your Honor.
Just briefly, Your Honor, may I make a brief record, Mr. Copeland?
Yes.
Mr. Copeland, you understand, though, that you are being bound over on these 3 counts. However, you have a plea offer up in circuit court. That if you accepted that plea offer would, as long as there's no allegations of wrong, for a clean set, would result in a dismissal of count 1 and count 3. Understand that, correct? You had a chance to talk to me about that. Understand the distinction. You are being bound over on these 3 counts, correct?
I thought he would be dismissed.
They would be if you take a plea deal up at circuit court. Okay. You understand?
Yeah.
Okay. Thank you.
Wait, one second.
He has questions. I don't think you understand.
Okay, so if I'm being bound over anyway, if I waive.
Do you want to go off the record?
Yes, Your Honor.
Okay, we're off the record. Get those questions answered.
Thank you.
Okay. We're on the record in the matter of the people of the state of Michigan versus Neva Danielle Brown, file number 23-00510. Council appearance.
Fran Ring on behalf of Theo Pressing under Michigan Code Rule 8.120.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Brown, who's seated to my right today.
Thank you. How are you, Ms. Brown?
Good, and yourself?
I'm well, thank you. Today is the date set for a preliminary examination. Count one, police officer assaulting, resisting, obstructing, and count two is the same. How are we proceeding, counsel?
Your Honor, this time is my understanding that Ms. Brown wishes to unconditionally waive her examination. The people do unconditionally waive the examination at this time.
Mr. Goodrich,
That is correct, Your Honor. Ms. Brown would like to waive her exam at this time.
is it an offer?
There was, Your Honor, it was to plead to either count one or it's a 1-for-1 offer. There's a plea to either count and we dismiss the remaining count, Your Honor.
Okay, so Ms. Brown, you understand the offer?
Yes, Your Honor.
Okay, you want to waive your right to have an examination in the district court?
Yes, Your Honor.
You understand the purpose of the exam?
Yes, I do, Your
Okay, so you understand that the purpose is for the prosecution to establish that they have sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. You understand that?
Honor. Yes, I do, Your Honor.
Okay, and you want to unconditionally waive your examination today?
Yes, Your Honor.
You understand that if you waive this and this matter is bound over, you can't come back later and request your exam?
Yes, Your Honor.
Okay, and similar to the last incident, you understand though that both counts are being bound over, not one's gonna be dismissed. You understood that?
Yes, Your Honor.
Okay. Anybody threatening you to get you to waive your exam?
No, Your Honor.
Were there any promises being made to you in exchange for you waiving your exam?
No, Your Honor.
So you're waiving it freely and voluntarily?
Yes, Your Honor.
Okay, your bind over date's gonna be March 15th. That's the date the circuit court will get the file from this court. You do not need to appear in court that date, okay?
Yes, Your Honor.
If your next court date will be a pretrial, and you and Mr. Goodrich will be made aware of that date. You still on the address at Madison?
No, I am on a different address now.
What's your address?
201 West Jolly Road, apartment 622. The zip code is 48910.
Yeah, 517 West Madison Street. Okay, we'll get that updated. And is your phone number still the phone number ending in 6538?
Yes, Your Honor.
Okay. Bond was set at 3,000, personal recognizance that will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
No, Your Honor, thank you.
You're all set, ma'am.
Thank you, Your Honor.
Ma'am, what's your name?
Calvin, Holtzman, sorry.
Oh, no, I'm talking to the lady here. What's your name, ma'am? I don't think she's on my docket anyways. I accidentally booted herself off. Okay, we're back on the record in the matter of Kelvon Copeland. And Mr. Copeland, you had further time to discuss this matter with your attorney. So do you understand the waiver is to bind over the case as it was originally charged?
Yes, Your Honor.
Okay, and you still want to waive your exam?
Yes, Your Honor.
Okay. Mr. Starks, did you have any other questions you wanted to ask of your client?
Thank you, Your Honor, for giving me the opportunity to clear this issue up. No further questions.
Okay, no problem. So as originally stated, the case will be bound over, bond will continue as originally set. And unless you have any questions for me, you're all set for today, okay? Thank you.
With the one this afternoon, I just spoke with Ms. Roll. She is intending to run that exam.
It's going at 1:30 on the dot.
Okay. I will inform her. You need to be out here no later than
This is Mr. Burnett.
Yes, ma'am.
We're on the record in the matter of the people of the state of Michigan versus Devery Curtis Barnett, file numbers 22-02187 and 23-00479. FYI, council appearance.
Brian Ring on behalf of the people practicing in Michigan Code Rule 8.120.
Good morning, Your Honor. Jacob Starr, support Assistant Public Defender here on behalf of Mr. Barnett. Mr. Barnett is present at council table. He's standing by.
How are you, Mr. Barnett?
I'm all right. How about yourself now?
I'm doing very well, thank
That's
you.
good.
Today's date and the time set for preliminary examinations on both files. How are we proceeding?
Your Honor, at this time, the people will be asking for an adjournment on both matters. On matter 22-02187, the people will be seeking an adjournment. Mr. Starks provided me with some information. I just need a little bit more time to look through that information to confirm or deny the information that Mr. Starks gave me. I can do that relatively quickly. And then on matter 23-00479, people are seeking an adjournment on that because of the day of the court's schedule change. Sorry. The court's schedule change. I wasn't able to get subpoenas out in time or confirm with my victim on that one that she did receive a subpoena or not.
Oh, sounds good. Okay, I was just reviewing the note from the exam, and it looks like there was a request to I'm sorry, I said the exam, I meant the PCC. There was a request by the defense to adjourn due to the overlap in another case.
Correct. A possible double jeopardy argument, Your Honor.
Okay,
Yeah, that would be
On the
two.
is
narcotic.
that what you're looking at?
That'd be 2187, Your Honor. Yeah, I had only had a brief moment to look over that,
Got it.
being
Sounds
out
good.
last week and just coming back.
Okay. So I assume there's no objection to that.
Well, Your Honor, Mr. Barnett, of course, would prefer to proceed today. He's made that very clear. But as an officer of the court, I did request an adjournment last week, and it's understandable that Mr. Ring might need some additional time, but I will note that we are prepared to proceed if Your Honor requested us to do so. Thank you.
Okay, so as it relates to both files, sir, you were scheduled to have a preliminary examination on the 3rd. You have the right to have had an examination within 21 days of your arraignment. I think you were arraigned on both of these back on February 10th. As to file number ending in 2187, I'm gonna find good cause to adjourn the timeline based on the request of the prosecution to have additional time to look into the collateral estoppel matter. On file number ending in 479, my schedule is the one that changed. So I'm going to find good cause due to the court's lack of availability to adjourn that to the next available date as well. Okay. Turn this to the March 16th at 9 a.m. March 16th at 9 a.m. That works for you?
Thank you, Your Honor. And just so the record's clear, I'd just like to make it very clear that Mr. Barnett, of course, would prefer dismissal, but Your Honor is ruled with cause. Thank you.
Okay, sounds good. File number ending in 2187, there was a bond set in the amount of 1,000 cash surety. That will continue. Other file ending in 479, bond is set at $300,000 cash surety with GPS tether and victim notification that will also continue. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Mr. Barnett will still be in custody at that point, Your Honor, so we'll need a red for him. I don't think I was.
Okay, sounds good.
Thank you.
Thank you. And so she's gonna try to come after we do this. So it must be during lunch.
Are we doing those, please?
Donnelly must have contacted and she's gonna try to get over here today after this exam. It's 11 o'clock. I don't know how many witnesses you guys have.
I have 3. I don't have everything printed for that.
Yeah, I don't know that tell her we don't know that it's gonna be able to go. We're in the middle of this.
I was gonna use my lunchtime in that exam to print off the rest of the stuff I needed to print off.
He's fresh off the bar exam. We gotta give him some grace. You took that UBE too, didn't you?
Yeah, it was.
First one in the state.
I had all week off last week and I come back and then they had me covering Flores on Tuesday with training the new guy and then your docket switches. So it's been a pump week.
Yeah. Ask Mr. Arthur, you just reset that for next week. Well, I'm not gonna ask him. We're resetting it for next week.
Thank you.
Okay. This is Mr. Greenwood.
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Robert Greenwood, file number 22-03335. FY counsel appears.
Brian Ring on behalf of the Practicing Michigan Court Rule 8.120.
Morning, Your Honor. Stephen Wilson, on behalf of Mr. Greenwood, who is present and seated to my right.
Today's the date and the time that was set for a preliminary examination, and my understanding is that you're ready to proceed. Is that accurate?
That is correct, Your Honor.
Yes, Your Honor.
Any preliminary matters?
No preliminary matters on behalf of you. Thank you, Your Honor.
And none I have the defense, Your Honor. Thank you.
You call your first witness.
People call Trooper Riley.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat, Trooper. Please state your first and last name, spell both of them for the record.
Keegan Riley, Keeganriley.
Thank you. Proceed, counsel.
Thank you. Trooper Riley, where are you employed?
For the Michigan Department of State Police.
What capacity are you employed there?
I currently serve as a task force officer for the U.S. Marshals on a fugitive apprehension team.
How long have you been employed there?
With the state police in general since June of 2012, and then in my current position for about 1 year.
And back in October, on October 5th of 2022, were you working in that capacity?
Yes, sir.
And were you in the vicinity of 1321 Vermont Avenue?
Yes, sir.
And why were you at that location?
I had been tasked with locating Robert Greenwood on a couple of outstanding warrants.
Have you had contact with Mr. Greenwood prior to this?
Prior to that, no.
And 1321 Vermont Avenue, is that in the city of Lansing?
Yes.
Ingham County, Michigan?
Yes, sir.
And so what happened when you were tasked to go apprehend him?
Part of that is obviously viewing photographs and everything, so I know who I'm who I'm looking for. So that was done prior to looking for him. On that date around that time, I observed Mr. Greenwood operating a black Chevy Impala in that area.
Was he driving or was he a passenger?
Driving with a female passenger. The vehicle was observed to go into the alley that would be on the west side of Vermont. So behind the houses. I'm familiar with that enough to know that there's parking for the houses on the west side there through that alley. After the vehicle went down the alley, I then drove behind there and saw the vehicle parked at that address on Vermont 1321.
Was the vehicle parked in a parking space or a driveway or garage? How's that set up?
I would call it a driveway for the house, which is the house it is also registered to.
Oh, so you looked up that vehicle's license plate?
Yes, sir.
And the vehicle was registered to that address?
Yes.
Who was the registered owner of that vehicle?
Tiffany Jones.
Did you approach that residence?
Yes, sir.
What happened when you approached that residence?
Myself, along with other team members on that task force, wore clearly marked police vests. We went to the front door. Before I knocked on the door, I could hear a male and a female arguing inside.
Could you make out anything being said?
Objection, Your Honor, that calls for hearsay.
You wanted to-
I didn't ask him to repeat what was being said, Your Honor. I just asked if he could make out anything that was being said, if he could overhear words or.
Okay,
Or if it-
without telling us what was said, you can respond to the question.
Yes, I did hear words.
Okay. And did you knock on the door?
Yes, I did.
Did you announce yourself?
Yes, I did.
And what did you say?
I knocked on the door and said it was police.
Did somebody open the door?
Tiffany Jones opened the door.
How do you know her name? Did she identify herself?
Yes, she identified herself. She's also.
Objection, Your Honor, now this is going to hearsay what someone else has said at this point, beyond the identification of this woman.
Objection sustained.
And did you eventually go into that home?
Yes, sir.
Did you receive consent to go into that home?
Yes, sir.
And what did you see when you went into the home?
Prior to even entering the home, I called out to Mr. Greenwood to have him come to us at the door. That way we could maybe even avoid going in. When I pushed the door open after receiving consent, I could see between myself and the bedroom in which I suspected Mr. Greenwood to be in, there was like an entertainment stand that had a pistol laying on it. So we proceeded into the home at that point beyond the pistol, so he would not be walking back.
Was the bedroom located, as you're facing the door, is the bedroom located off to the right of where you went in, straight ahead, or off to the left?
So you would walk straight ahead, probably 10 to 15 feet, and it was on the right.
And it was on the right, and it was on the right of where you saw that pistol located?
Yes.
And so what did you do next after you saw that?
We just moved forward beyond it, closer to the doorway. Mr. Greenwood came out and surrendered himself. He was placed in custody.
You made contact with Mr. Greenwood?
Yes, sir.
Did you speak with Mr. Greenwood at all?
Once he was outside, I can't remember if I asked him if he needed me to get anything.
Objection, Your Honor, if the witness doesn't know if he said it or someone else said it, then that definitely calls for hearsay, even speculation at this point.
Well, he said he can't remember if he asked him. I don't know if he was gonna say, were you about to tell us what someone else asked?
I couldn't remember if I asked Mr. Greenwood if he needed anything or if Mr. Greenwood told me he needed his medication.
Got it. Objection overruled.
So either Mr. Greenwood told you he needed his medication or you asked him if he needed anything? Is that what you were saying?
Yes, sir. It was one of the two. And during that course of conversation with Mr. Greenwood, he asked me if I could grab his methadone prescription out of the top drawer in the bed.
And did you go back to the bedroom to grab that methadone?
Yes, sir.
Did you find what you were looking for?
When I originally went into the room, there were two dressers and a nightstand. I didn't know which top drawer he meant. And looking in each top drawer, I didn't see any prescription bottle with his name on it, with any pills in it. I'm sorry, with any methadone in it. There was the first dresser when you walked in was the one that had men's clothing in the top drawer. so I assumed that would have been his dresser. And there was a gray case, like a lockbox style case, in that top drawer that would have been big enough to fit a prescription bottle. It was unlocked, so I opened it, and inside was a box of ammunition and what looked like a small baggie with suspected methamphetamine inside.
And what kind of ammunition was it? You recall?
The box said 45 ACP. I did not actually.
And you said the other contents of that top drawer were what you suspected to be meth and men's clothing.
Yes.
Did you do anything else after that?
I contacted Trooper Harshman to respond to the scene to assist with the investigation, as we do not maintain property lockers or anything like that. I knew the items had to be seized, and I was going to be unable to, I guess, fulfill that task.
No further questions this time around. Thank you.
Prosecutor.
Thank you, Your Honor. Morning, sir.
Good morning, sir.
You indicated that you saw a car going into or to the property that you were observing or surveilling. Is that correct?
The car was seen going into the alley. I didn't actually see it pull into that.
Okay. And the person that you saw driving the vehicle, was that the owner of the vehicle?
I saw Mr. Greenwood.
So the owner of the vehicle was sitting next to him. Is that correct? Did you later come to find out that the person sitting next to him was the owner of that vehicle?
I would suspect so.
Okay.
It was a female. That's all.
Now, without saying what she said, later on in your investigation, did you end up talking to this woman?
I talked to her at the front door of the residence.
Well, she's the one who opened the front door. Is that right?
Yes. Sir. So
And she was the owner of the residence, correct?
I believe she's registered to live there. So I don't,
She's,
ownership rent, I don't know about that, but she resides there.
okay. But she's the sole owner, resider, tenant, individual who lives there. Is that correct? On legal forms and everything else like that?
That is going to be a question I'm not able to answer.
Well, you indicated that the car was registered to this woman, correct?
What I mean is, as far
Was
as
the car registered to this woman?
yes, sir.
And was the owner of that car registered to the same house?
Yes, sir.
So it would be that same person, correct?
I would assume it was the same person. I don't understand, I guess, exactly. What
Yeah, I think you lost me there too.
The individual who owns the car,
yes, sir.
you said you connected it to the house, correct?
Yes, sir.
So the same person who owns the car owns the house.
Well,
I don't know.
Yeah,
This is what you testified to earlier.
What I said was, I believe she is registered to the house, whether she owns it, whether she rents it,
yeah,
whether.
this was, he answered that he doesn't know if she owns the house or not.
So the testimony, the vehicle was registered to Tiffany Jones, is that right?
Yes, sir.
And that you indicated is it that you thought the car? What was the connection between the car and the house, between the registered owner of the car and the house?
The registration for the vehicle, it provided her name of Tiffany Jones with the address on her.
Okay, so the address.
The vehicle is registered through that.
Okay, I apologize. That was my mistake. Thank you for clarifying. Was there anyone else on the title of the vehicle?
To my knowledge, no.
So when you approached the house, you knocked on the door, you said, correct?
Yes, sir.
And you went inside?
Yes, sir.
And you went inside because you saw a gun on a table, correct?
Yes, after we had received consent to arrest Mr. Greenwood, like we were given consent to enter, but I didn't see the need. He seemed to be compliant. If he would have walked out to us, I had no intention to actually walk in. However, when I saw the pistol, I obviously don't want him walking past that to get.
Who gave
So
you
that was
consent to
why-
enter?
Mrs. Jones, or Miss Jones.
And that's the owner of the house?
Yes, sir.
And you escorted the suspect outside, is that correct?
Yes, sir.
While you were outside, at this point, when you just get him outside, had anyone gone in the room and searched yet? In the bedroom? Had anyone searched in the bedroom yet?
No, sir.
Where was Ms. Jones at this time? Right when you take him outside, where was Ms. Jones?
I can't remember if she came outside. I know originally we had her step out with us. After he was outside, we had her go back into the living room at some point, but I don't remember exactly if that was exactly the time. But between the living room and outside on the stoop, Mr.
So she was outside on the stoop shortly after you brought him outside?
Yes, sir, at some point.
And you're saying that either you asked my client if he needed anything, is that right?
Yeah, it's very common, like, for some, do you need a cell phone? Do you need your ID? Do you want to bring any of your cash with you? So it's possible I asked him if he needed anything. It's also possible he asked me first. I don't remember. Because those are common requests that people will ask us as soon as we arrest them. So I just don't.
So he asked you rather than Tracy is what you're saying?
Yes,
The woman who was there with him?
Tiffany, but
Tiffany, Ms. Jones, correct?
yes, sir, that was a conversation between myself and Mr. Greenwood.
Now, when you went into the bedroom, did you find any methadone?
It's hard to say. After
Did
I
you
was,
find a prescription bottle for methadone?
no,
So right now, we only have your word that my client asked for methadone at that point, correct?
yes, sir,
You don't have a body cam, do you?
no, sir.
And you got permission to go in when there was no one with a body cam around. Is that fair to say?
Trooper Harshman would have been the only one that would have had a body cam, and I don't think he was there at that time. No, he definitely wasn't there at that time, sir. So, correct.
You indicated that you were given permission apparently for looking into the top drawer. Is that right?
Yes, sir.
Now, when you looked in the top drawer, there were several places that had top drawers according to you,
I think that, yes, that's accurate.
like a nightstand.
There
And
was a nightstand and there were two dressers.
was anyone else in the room with you at this point?
I don't remember.
You're not the individual who took pictures of the dresser, is that correct?
That's correct.
You did look through all the dresser drawers though, correct? And I'm sorry, let me back up. When I say the dresser, in the bedroom when you first walk in, there's a 4-drawer dresser, is that fair? 4 or 5?
It was an upright dresser with multiple drawers. I don't remember how many, but
All stacked up, the drawers,
yes,
one on top of the other?
yes.
Okay, and TV on top of that dresser?
I don't remember. There was a TV on top of that.
It was across from the bed though, right?
Yes, sir. It would have been on the far southern wall, like right when you turn into the room, it would have been the first dresser there. If we're talking about what I attribute to be the men's dresser.
I think we're both on the same page.
Where
I
the
think
items
so.
were located, yes.
Yeah. You looked at the top drawer, is that right?
Yes, sir.
And you also looked at the other drawers as well, correct?
No, sir.
You're not the individual who took pictures?
No, sir, I'm not.
Did you get permission to go into the lockbox?
I was given permission to go into the top drawer and get the pill bottle. The lockbox was large enough to contain a pill bottle.
Okay, so you were not given permission to go into a lockbox.
I think that's argument semantics. I would
Okay.
say I was.
You were given permission to go into a top drawer, correct?
Yes, sir.
Within that top drawer, there's another little box in there. Is that correct?
Yes, sir.
All right. Did anyone say, please go into the little lock box?
Okay, no, that was specifically not said.
Just for my clarification, the lockbox was in the drawer? Is
Sorry,
that-
was the lockbox in the drawer?
Yes, Your Honor.
When you opened the lockbox, is that when you saw ammunition?
Yes, sir.
Is it illegal to own ammunition?
I knew Mr.
Without
Greenwood-
knowing anything more, is it illegal on its face to own ammunition?
Okay, no, sir.
And there was what, did you say, like, what else did you find in that little lockbox?
There was a small little tied up baggie with what looked to be methamphetamine inside. I believe there was a pair of brass knuckles as well, but I would have to review the photographs for sure.
You're not certain?
I'm not certain.
Now, was it immediately apparent when you looked in there in this little baggie, you knew immediately that this was controlled substance of some sort?
I suspected.
I suspected it wasn't immediately apparent though.
I guess, could you explain to me what you mean by immediately apparent? I would say that I have to say suspected without having some kind of field test or lab test.
You look into you see a gun, you know what a gun looks like. You said you saw one on the in the TV room stand, correct?
Yes, sir.
And you knew right away, it was immediately apparent that was a gun,
Then I would say yes, it was
All right.
immediately apparent that it was methamphetamine.
even without testing it?
If that's the standard we're going by.
By looking at it itself, you could determine immediately what it was, is what I'm trying to say.
Objection, Your Honor. He's already said he doesn't know exactly what it was. He's already said multiple times he suspected it was. Mr. Milk's just delaying the point and keeps arguing the same point to him.
I think the original testimony was that he was suspected methamphetamine, correct?
Yes, Your Honor, I suspect. it.
Okay, and so now the question is, was it immediate apparent?
Was it immediately apparent? Yes.
And he answered that he can't use that standard, probably based on his training and experience. And you gave an example. It sounds like he was trying to concede to satisfy an example. Is that what you're doing, sir? Is you don't have to concede, if you can't, you need to answer the question
When he
based
put-
on a trooper.
when he put it in the terms of, I saw what appeared to be a firearm, and I can say that's readily apparent to me. By that standard, I would say that it was readily apparent to me that that was a small baggie of controlled substance. If that's the standard, I mean, they manufacture BB guns every day that look and feel just like firearms. So from that distance, if it's readily apparent to me that that's a firearm, I guess I would say by that standard that you're explaining.
I'm not really sure that we can compare the two in standards. What does methamphetamine in a baggie look like?
Cornered bag, ripped, tied, about yay big, and it's gonna be a white crystal-like substance just stuck in there.
So you wouldn't be able to readily appear what it is unless it was tested, or do you have to test it to find out? Could it have been something else?
I would use the phrase, I suspected it to be methamphetamine, which is what I originally said.
Okay,
And I feel like he's trying to.
and then he may be, but you're the witness.
Right, I
And
would
so
say,
you don't have to change your testimony
okay,
unless that's what you want to do.
I would say I suspected it to be methamphetamine based on my training and experience.
Did you pick up the bag at all?
No, sir.
No further questions, Your Honor. Thank you.
Can you redirect?
Very briefly, hang on. I might have one moment.
Trooper, did you test the suspected meth?
No, sir, I did not.
Did you remove the suspected meth?
No, sir, I did not.
And you said among the things in that, did you check the top drawers of the other, you checked the top drawer of the dresser? You checked the top drawer of either of the nightstands?
I checked the top drawer of the nightstand and both dressers, when I didn't find a pill bottle.
And in the one dresser, you found men's clothing,
Yes, sir.
you found ammunition
Yes, sir.
and the suspected meth,
Yes, sir.
and that was in the same one with the men's clothing.
Yes, sir.
And the other dresser did the other dresser have any clothing?
Objection, Your Honor, at this point, it's just that he's leading again and again. He's suggesting the answer in his questions at this point.
Objection sustained.
Did the other dresser have any clothes in it?
Yes, I had clothing.
What type of clothing?
They appear to be female.
Thank you. And is the person that you went to arrest and arrested that day, are they sitting in this courtroom today?
Yes, sir.
Could you please point to them and identify something they're wearing?
Wearing the long sleeve white shirt with the blue over it.
Let the record reflect that the witnesses identified the defendant.
We have objection to
No objection, Your Honor.
So noted.
No further questions, Your Honor. Thank you.
Okay, and the Trooper Riley be excused?
Yes, Your Honor.
Thank you, Trooper.
Thank you, Your Honor.
Call your next witness.
The people call Trooper Parchman.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Thank you. You can have a seat. State your first and last name and spell both.
Calvin Harshman, CalvinHarshman.
Proceed, counsel.
Thank you. Trooper Harshman, where do you work?
Michigan State Police here in Lansing,
How long have you worked there?
just over 5 years.
And in what capacity?
As a road trooper.
And were you working as a road trooper for the Michigan State Police on the 5th of October of 2022?
Yes, sir.
And on that day, were you in uniform?
Yes, sir.
And were you in the area of 1321 Vermont Avenue?
Yes, sir.
Is that in the city of Lansing,
Yes, sir.
Union County, Michigan?
Yes, sir.
Why were you in that area?
I was called by the fugitive team who arrested a gentleman, and they found contraband that they needed me to take and secure for them.
Did you arrive on scene?
Yes, sir.
About how long did you arrive on scene after you got that call?
About 15 minutes probably.
And what did you see when you arrived on scene?
I saw the first district and fugitive team outside with Mr. Greenwood outside of the residence.
Was Mr. Greenwood detained at that time?
Yes, sir.
Was there anybody else outside that residence at that time?
Outside of the residence, no.
Did you eventually go into the residence?
Yes, sir.
Why did you go into the residence?
To meet with the officer who called me and the female who was living at the residence was inside with them.
And what did you do once you were inside the residence?
I spoke with the detective trooper who was inside there, and then spoke with the female who lived there, and then secured the contraband that was inside the house.
But when you say you secured the contraband inside the house, what do you mean?
There was a firearm on a TV stand in the living room. I secured that, and then in the bedroom, in the dresser, I secured ammunition and narcotics.
Where did you secure this ammunition? You said it was in the dresser. Where at in the dresser?
Yes, so it was in the top drawer inside of a black box.
And what kind of ammunition was there?
There was 45 caliber and 9 millimeter ammo.
And you said you also secured the handgun?
Yes, sir.
What kind of a handgun was that?
It was a 9 millimeter handgun.
When you secured that, were there any rounds in the chamber?
Yes, sir, there were. Not when I secured it, no, there was not. It had been, there were rounds in the magazine, but it had been made safe by the detective trooper there. So they were not inside the handgun when I secured it.
And what else was in that top drawer?
Ammunition, suspected narcotics, a pair of brass knuckles, and also in a drawer with men's underwear, but they weren't inside of that box.
Did you speak to Mr. Greenwood at any time?
Yes, I did.
Did Mr. Greenwood ask you to retrieve anything?
He did not ask me to retrieve anything, no.
Did you overhear, were you there when Detective Riley was speaking with Mr. Greenwood?
I was not there, no.
And so what did you do with the suspected narcotics once you secured it?
I placed it in a bag, a property bag, took it to the post where it was tested.
Did you label that bag?
Yes.
And you turned it over at the post?
Yes,
Who
sir.
did you turn it over to?
I put it in our property lockers, and not detective, but the sergeant, property sergeant just controlled that there once he arrived.
No further questions. Time, Nick, there.
Was the box inside the drawer, was it locked?
No, it was not.
Okay. Cross-examine.
Thank you, Your Honor. Just two quick questions, sir.
Yes.
When you arrived on scene, you said that the defendant was outside, but no one else?
The rest of the fugitive team was out there.
Okay, all right. When you went inside the house, you said there was a female. Did you come to learn that was Ms. Jordan?
Yes, sir.
She's the owner of the house?
I'm not sure if she's the owner, but she lived there, yes.
Okay. No further questions, thank you, Your Honor.
No to reader. Thank you, Your Honor.
Okay, thank you, Trooper Hushman.
Thank you.
Call your next witness.
This time people call Sergeant Smith. Can you get Sergeant Smith? Trooper?
Yes.
Thank you.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. State your first and last name and spell them both.
Sergeant Pete Smith, P-E-T-E, S-M-I-T-H.
Proceed, Counsel.
Thank you, Your Honor. Sergeant Smith, where do you work?
For the Michigan State Police,
How long have you worked there?
approximately 22 years.
In what capacity?
Currently, I serve as the property room sergeant.
And what are the duties of the property room sergeant?
I maintain the evidence that comes into the property room. I test controlled substances.
Are you familiar with the True Narc device?
Yes, I am.
Have you had training on that True Narc device?
I have. I am a certified True Narc operator since 2019.
Do you have regular trainings on that True Narc device?
No, once you go through the initial training, you're certified to operate the device.
On the 5th of October of 2022, did Trooper Harshman bring anything to the evidence room?
I don't know when he secured the evidence into the temporary lockers. I know I retrieved the evidence out of the temporary lockers on October 13th, 2022.
And is each individual piece of evidence labeled in some way?
Yes, it is.
And can you kind of describe that labeling system?
It's got a barcode and an incident number and a property item number, a bright yellow tag, just like the one that's in front of you there.
Can you kind of describe the process of when you take something out, when somebody puts something in and then you take something out of that?
Yeah, so we have it's called temporary locker system. It's accessible to the trooper from one side. Nobody else except myself can get access to it on the other side. So they would secure it in one of the temporary lockers, lock it via push button mechanism. And then the only way to retrieve it is from the inside of the property room where I can open the door and retrieve the property out.
And do you log when you take property in and out of there?
Correct, it's scanned into a computer system that logs when it enters the property room.
And on the 13th, you remove an item from that evidence locker?
Correct.
What did you remove?
Was identified on the property label as suspected methamphetamine.
It was identified on the property label by who brought it in and that report number?
Correct.
And did you test that property?
Yes, I did.
Did you test it on that TrueNarc device?
That is correct.
What were the results of that?
The TrueNarc device indicated positive for methamphetamine.
Did you test it more than once or just the one time?
Just one time.
Is there a process for testing? Do you test it on something else before, or do you just test it?
The machine has internal standards that it checked itself with, so those internal standards are checked prior to the testing of the suspected controlled substance, and then it's also checked after you test that controlled substance.
And you did both of those internal, or both of those checks?
Correct, and that passed both times.
Okay, thank you. No further questions, Your Honor.
No questions, thank you.
You may be excused, Sergeant Turner. Call your next witness.
People arrested. Oh, actually, I apologize. People not arrested. Your Honor, at this time, I'd like to submit for evidence people's proposed exhibit 1, which is the certified copy of conviction for Mr. Greenwood.
And I did have an opportunity to review this beforehand, Your Honor, pursuant to the purpose of the prelim. Obviously, it's admissible. Prelim, so.
May I approach, Your Honor?
You may. People's exhibit 1 is admitted.
Thank you, Your Honor.
Thank you.
At this time, the people are arrested. Your Honor.
Thank you. Is the defense calling any witnesses today?
No, Your Honor.
Okay, you can see the argument.
Thank you, Your Honor. Your Honor, Trooper Riley, as part of the fugitive team, testified that he was tasked to apprehend Mr. Greenwood. He identified Mr. Greenwood. That he looked at pictures and saw what Mr. Greenwood looked like before he identified him in the court today and identified him in the vehicle. The vehicle was ultimately parked behind an address located in Lansing. He went to go apprehend that individual, knocked on the door, had permission to enter. To apprehend that individual, Your Honor, there was a pistol on the TV stand by the room that the defendant ultimately came out of, Your Honor. He was then asked by the defendant if there was anything that he needed to retrieve. The defendant indicated to him that there was methadone located in the top drawer. When he went in the top drawer of the dresser, Your Honor, to locate that methadone, he found what he suspected to be possible methamphetamine, which was later determined by which was later collected by Trooper Harshman, tagged into evidence, and tested by Sergeant Smith as positive as methamphetamine. Inside this drawer, there were also men's clothing. There were also men's clothing inside this drawer. as well as ammunition and brass knuckles. There was also 9mm ammunition, which was the same style as the handgun that was located and recovered, Your Honor. At this time, Trooper Harshman did recover that gun as well, Your Honor, and that gun was a 9mm, and there were Trooper Harshman recovered the ammunition from that drawer as well, and did confirm that there were also men's clothing in that dresser, whereas the other dresser contained women's clothing. Your Honor, at this time, the people would also be requesting to add ammunition possession by a felon under 750224F6. And that would be ammunition possession by a felon, which was found in there. And Your Honor, I have provided a certified copy of Mr. Greenwood's criminal sentencing that he is a felon, Your Honor. I would ask that you bind over on all counts this time, Your Honor. Thank you.
Mr. Melton.
Ron? Your Honor does indeed have a certified copy. Your Honor, I'm asking that the court dismiss all charges against my client at this time. Explaining why, Your Honor, the court does have a certified copy of the prior conviction from 2004, I believe is what the date of it. The statute requires the prosecutor to be able to show that less than 5 years have passed since the terms were successfully completed. This is well outside of 5 years, Your Honor, per statute. Therefore, both the current charge as well as the requested charge by the prosecutor must be dismissed at this time. It's just plain and simple per statute. Regarding the dresser drawer drugs, there's been zero indication that my client lives at that house, stays at that house, is in what relation he has with Ms. Jones, who's the owner of the house, we suspect, who is definitely the owner of the car, which belongs to the house. No one else that we've heard of, at least no evidence so far, has been shown that my client has any ties to this house whatsoever. And the one thing that the prosecutor's come to is said, well, there was maybe some men's clothing up there. Well, that's subjective these days and age. What is men's and what is women's clothing would be a certain kind of gender bias on behalf of the prosecutor at this point, unless there was some sort of question or discussion with Ms. Jones as to whether or not those were her garments in there. Even if they weren't her garments, we've got no indication that she doesn't have either a son, friend, husband, something else living there. Just to assume that my client lives there because he came home, drove her home with her car. She may have a DWLS. She may not be able to drive. She may have a hurt foot. She may be blind in one eye. There's 1,000 different reasons someone could drive someone else's car home. There's been no indication so far that my client knew about drugs in that drawer, had any idea there were drugs in that drawer. At this time, Your Honor, there has not been sufficient proof to bind over on this matter to show that my client was even closely in possession of the drugs at this point. Possession has a very specific requirement here, Your Honor. And as the courts have routinely stated at these times, that the link between defendant and narcotics must be shown to establish constructive possession. It is well established that a person's presence by itself at a location where drugs are found is insufficient to prove constructive possession. That's People versus Harper, 365, Mitch, 494, 1962 case. And there are plenty of other cases that also back that one up, including People versus Wolf, 440, Mitch, 508, 1992, amended October 9th, 1992. Constructive possession refers to the actual physical possession that can be inferred from the circumstances surrounding an arrest. In other words, how can we show that my client actually handled that? There's been fingerprints. There's been nothing indicating that my client knew that stuff was in there, Your Honor. At this point, it is just over and abundantly clear that the prosecutor has not met their burden at this time. The case must be dismissed against my client. Thank you.
Can I have 1 second, Your Honor? At this time, I believe there is enough to show that the meth was, by this court standards for today's preliminary exam purposes, the methamphetamine found was the defendant's, and the defendant knew about it. The defendant asked the trooper specifically to go into that drawer, to go into the drawer to retrieve his methadone. He asked to retrieve his prescription. He was keeping prescription. That shows, Your Honor, that he was keeping prescriptions at this location, Your Honor. You don't keep prescriptions at a place you're just visiting.
Objection, Your Honor, this is facts outside the evidence. There was no prescriptions found, obviously.
Well, I recognize there was none, but I think that the argument, I don't think he said that there was some found.
I didn't say there were prescriptions.
He's arguing at this point that people don't keep prescription in drawers or something like those lines.
Right, but we have a testimony that he instructed the officers to go get it out the drawer. So I think just based on the instruction is what we're arguing. The court is clear that there was none found.
Right. I mean, I'm not trying to say that there was any prescription found. I was generally alluding to people don't generally keep prescriptions or say that they have a prescription in a place that they're not living at. Or that they're not currently residing at. And so he knew that there was something in that drawer. He knew that there was meth in that drawer, and it was his. And I think the facts show that, at least by probable cause standard, that it was probably his meth, Your Honor. Thank you.
Not gonna address
I was looking at the jury instructions.
That's the one I'm more concerned about you addressing, because that was why I paused before I told you to go to argument, because I'm looking at I was looking at the judgment of sentence. It's not even for what was named in the complaint.
Or may I just one thing briefly? Thank you. Your Honor, if my client even said, please go get my prescriptions, which we obviously, and I think the court's pretty aware that we're going to test at some point. Methadone is a treatment for heroin, if that were even true, and to all of a sudden make the leap that, well, that's connected to methamphetamine is quite a giant leap. The indication was that there was a top drawer, not a specific drawer or something. No indication that my client knew that there was actually meth in that particular room, in that drawer. At this point, there's been no evidence of that so far, and it's attenuated, not even attenuated. It's not there, Your Honor. My client was actually living there with a relationship with. So, thank you.
Your Honor, I don't have any response to that. I did provide the court with a certified copy of conviction for an offense that is outside that window and is not even for the offense listed in the complaint, Your Honor.
Today was the date and time set for preliminary examination. Mr. Greenwood, for your information, the purpose of the preliminary examination is for the prosecution to meet their burden, which is to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Probable cause is a relatively low standard. It's not a standard even close to being compared to the standard that the prosecution would have to face if this matter was to make it to trial. At trial, they have to prove each element of the charges being brought against you beyond a reasonable doubt. Today, the standard is just more than mere suspicion that a crime was committed and mere suspicion to charge you with that crime. And so here we have testimony. First, we had, I think, two troopers and one sergeant from the Michigan State Police. Trooper Riley testified that he reported to the address of 1321 Vermont, City of Lansing, Ingham County, State of Michigan, back on October 5th, 2022, making venue before this court appropriate, and that he was tasked with locating the person he identified as Mr. Robert Greenwood, the defendant here in the courtroom, on an outstanding warrant. He alleged that he located the defendant operating a black Chevy Impala. That Impala was registered. There was a female passenger. He stated that the vehicle was registered to a Tiffany Jones and that the address of the 1321 was the registered address of the vehicle as well. He approached the door, knocked on the door. He said a person who identified themselves as Tiffany Jones opened the door. He later testified that there was consent to arrest or to enter given by the occupants of the home, and that when he was taking Mr. Freeman into custody, that Mr. Freeman, he couldn't, the officer or the trooper couldn't recall if Mr. Freeman requested or if he suggested. One way or the other, there was some indication for the trooper to go and retrieve a prescription for methadone from a top drawer. Trooper Riley testified that he went into first. He testified that there was a firearm that was located or seen on the table in the entertainment room, or a pistol. And as he went into the room, he was unsure as to which drawer was meant. I guess he was given instructions to go to the top drawer. Nonetheless, he said he didn't know which top drawer was meant, that he looked, it sounds like, into two top drawers. There was one drawer in particular that he said contained some men's clothing. There was a lock or located a lockbox of some sort inside of that drawer. Inside that drawer, there was ammunition with a small baggie that he suspected to be methamphetamine, and which was later tested by Sergeant Smith and determined to be methamphetamine. So the defendant in this case is being charged with count 1 of controlled substance possession of methamphetamine as to see, and then count 2 weapons, firearms, possession by felon. The people are asking to add a count 3 of ammunition possession by felon. Okay, and so to prove this at trial, the people would need to prove first the defendant possessed the controlled substance that they're was determined to be methamphetamine. Second, the defendant knew that he possessed the controlled substance. And third, that the substance that the defendant possessed. I think I have the wrong jury instruction. 1 second, I have the wrong jury instruction. Okay. I'm using jury instruction 12.5. Should I be using a different jury instruction on this? This requires a weighted mixture.
Which one are you using, Judge?
I'm on criminal jury instruction 12.5.
So.
Am I using the correct one?
Trying to spell nothing. 12.1 is unlawful manufacture. Oh,
On
12.5, sorry.
Yeah.
I was looking at 12.1 for some reason.
Yeah, it's the only possession, absent the one with intent to deliver. This is not being charged. This is just controlled substance possession. 12.5 is the unlawful possession of controlled substance, but it requires a weighted mixture.
Yes, you do. I believe that's the correct instruction.
With that being understood, third, it will require the people to prove at the time of trial that the substance that the defendant possessed was in a mixture that weighed, and they would need to state the weight. Don't see where this was charged as is with the weight listed here, but we did have testimony from Sergeant Smith that he was the individual charged with processing the evidence, and he tested the evidence and found it to test positive using TrueNarc for methamphetamine. This was methamphetamine, or a bag suspectedly methamphetamine was located in a drawer, a top drawer in a home, which the only information for the court is that the defendant was in that home and he was driving the vehicle that was registered to a Tiffany Jones, and that was the address of Tiffany Jones. The court's clear as to that, and that the Tiffany Jones is the person who she identified herself as Tiffany Jones when she opened the door, and the defendant was there in the property. The court's unclear as to what the relationship is between the defendant and Ms. Jones, but there's obviously some relationship because seen driving her vehicle, she's a passenger. Then she opens the door, he's in the home. There was instructions given by the defendant, according to the officer, for him to retrieve a prescription, which the prescription was never found. But the argument of the defense is that there's no evidence to demonstrate whether or not his client, Mr. Greenwood, knew what was in that drawer. I think that the element of concern for the court is that there was instructions for the defendant, or from the defendant, to go into a top drawer, and that this, according to the officer, was the only top drawer that had men's clothing or underwear in there. And there may be an argument that the men's underwear belonged to a son, or it may be an argument that the men's underwear belonged to Miss Jones. But that's an issue to be properly fleshed out before a jury at the circuit court. So as to count one, the court is satisfied that there's probable cause to bind over as to count one, controlled substance. Count two, weapons, firearms possession by felon, that will be dismissed because the prosecution has failed to provide sufficient probable cause. This was charged at first as weapons, firearms possession by felon, and that the defendant did allegedly possess a firearm when ineligible to do so because he had been convicted of home invasion first degree, a specified felony, and the requirements to regain eligibility have not been met contrary to MCL 750.224F. I have a certified judgment of sentence here, but it is for police officer assaulting, resist, obstructing from June 2004, which does not meet the statutory guideline. And so count two will be dismissed. The court will also not be granting the request to add a count three. So count one will be bound over to the circuit court for further prosecution. Your bind over date is March 15th. You do not need to appear in court on March 15th. That's the date they get the file from this court. Your next court date will be a pretrial. You and Mr. Mills will be made aware of that, okay? You have any questions today, sir? Do you have any questions? You may, thank you.
Your Honor, just for purposes here, the court made some mention regarding the weight. Because the suspected drug here is methamphetamine, it doesn't fall within this requirement. It's not a narcotic drug or it's cocoa leaf derivative here, Your Honor. So I don't, that element doesn't need to be satisfied at this point. Plus, it's also a preliminary examination. Having substance has a weight to it, I guess, but.
Correct. They would have to prove that at trial, but this is not a trial. This is only probable cause standard. And I can't recall if Sergeant Smith mentioned the weight. I'm inclined to believe that he did weigh it, and then maybe the prosecution will have to make a motion to amend their complaint to clarify that later. But for the purposes of today's proceeding, there's sufficient probable cause as to count one.
No further questions, Your Honor. Thank you.
Thank you. Bond was set at 10,000, 10%. That will continue. Any additional matters for the record?
None on behalf of people. Thank you, Your Honor.
And none of the defense. Thank you, ma'am.
Thank you. All set. Court is in